Over the last couple weeks, we've had a couple of small groups get together to discuss some of the trickier parts of this so that we could get it in a better for the group.
Oh, Joanne, some strange feedback. Here, I'll mute myself. Everybody who's not talking, let's go mute. Try to get Lorianne.
Okay.
Sorry, Lane, I think I know what happened. Try again. Or Lorianne, try again. Go for it.
Okay. So the two big things that are different from the last time that we met have to do with in the chapter 111, the bigger draft that you received from Sandy. I apologize, first of all, the date on the top of that indicates it's 5/20/20, but it's actually 7/14/20. The date on the bottom of that page is correct. So the biggest change has to do, section 2 in this draft is talking about when ORCP applies to contested probate proceedings. And then the other big change has to do with the second document that Sandy sent to y'all that's really mostly focusing on a parent's ability to make decisions on behalf of their child in a probate and what the limitations on that are. And so why don't we go ahead and start with the ORCP. So this is section 2 in the ORS chapter 111 working draft. This was put together by mostly, I think, by Brooks and Matt with input from Jennifer and Heather. And basically what it's saying is that except for where otherwise already provided in the probate code in these specific statutes, that the ORCP and the Oregon Evidence Code won't apply to probate proceedings. And then it goes on to provide the exceptions to that exception. So ORCP 12 will always apply. That's the same as what was in the last draft. The biggest change in this has to do with how we define what a contested probate proceeding is. And we actually moved away from that term, and it's now a contested issue in a probate proceeding. This is in subsection 4 of section 2, and it lists out all the various filings that would trigger the ORCP application. So I think I might let Brooks or Matt take the lead on this, because this is kind of their project to explain the reasoning behind these particular issues.
Looks like Brooks isn't on, so that leaves it to me. The goal here is to provide that we know exactly when the ORCP apply and when they don't. And so the way that we tried to set this up is to establish rules such that when someone is asking the court for relief that is going to potentially have an adverse effect on a person, or in the alternative, when there is any motion or petition to which there's an actual objection filed, then we know that both the evidence code and the ORCP, or at least those specific ones that we think make sense in probate, apply. The tension that we set up and that we've really wrestled with is trying to capture the idea that when you have an issue that's going to be governed by, procedurally by the ORCP. So for example, when you have a plain vanilla probate that's got plenty of ordinary administrative tasks, which wouldn't necessarily invoke the ORCP, but within that you do have you have some matter which is contested, maybe a petition to determine heirship or something like that, that we know that the ORCP apply with respect to that separate and concrete dispute, not the whole proceeding. In other words, we want to know when we are launched into the sandbox under which ordinary litigation style rules apply and when we are not. And so what we tried to do here, and I hope we did it well, but I'll defer to everybody's more careful eye. What we tried to do here is we tried to say that, number one, when you have a contested issue, those procedural and evidentiary rules apply with respect to that contested issue, but the rest of the probate may continue under, the ordinary, standard ORS 111-205, no particular forms of pleading or procedure apply in the probate court. Continue.
Yep.
And,
I think it's a great approach. What I like about it is the laundry list clearly identifies those matters that are going to be subject to the ORCP. So it's not a matter of trying to use general directives or guidelines to try and determine, and you've left the court the ability to declare a matter of contested proceeding. I welcome comments from everybody on that whole approach and the way that's drafted.
And on that very last note, Lane, that point, which is that we need to maintain and build in, or rather, just maintain, because it's already built into the probate code, the ability of a judge under proper circumstances to look at a situation that Jennifer and Heather and Brooks and I didn't imagine when we workshopped this, that a probate judge should be able to say, oh, they didn't think of this one, but this is obviously a litigation situation where the ORCP apply, and that's why we have that catch-all provision at the end.
Or it might be the kind of thing that wouldn't necessarily be in the laundry list, but given the particular circumstances and flavor of this particular probate, it may be something that the court would want to have more strict rules apply to. Comments, questions? I just had one on the drafting, and it's the whole, you touched on it at the beginning. We're not going to call it a proceeding. We're going to call it an issue. But I guess it works. But an issue to me sort of means sort of a focus of a particular dispute within the context of a proceeding. And what you really listed here are not so much issues. If you look at the laundry list, those aren't issues. Those. And if we don't want to call them proceedings, do we call them matters or something? I don't know. It's an odd use of the word issue.
And Lane, I'm laughing because we spent probably 40 minutes on this on Tuesday.
Okay.
I mean, on that exact issue. Because
that's the point of controversy.
Right, because what we don't want to do, and so specifically, we had proceeding, we had contested probate proceeding in the first 3 or 4 iterations of this.
And why did you, okay, yeah, so what was the thinking about that?
Well, the problem is that the probate matter itself is the proceeding.
Right.
It's that case number. And what we didn't want to do, and that gets back to exactly that tension I was just talking about, which is to say, we don't want to create a situation where people who aren't in this drafting committee, right? People look at this and say, oh, right, because I have this one contested phase, this one contested thing going on in the probate, therefore the ORCP apply to everything that we do, even the things that are not contested. And so the word issue, it's absolutely not the perfect word. I don't think that we have the perfect word.
Did you try on the word matter?
That Lori suggested. Yes. Lori suggested matter.
Well, this is Jennifer, and Lane, you said something that gave me the idea of another word. We could call it a controversy in a probate proceeding instead of a contested issue.
I'm not sure I like that better. Well, maybe we just live with it. As long as we define it, then for the purpose of this section of this chapter, these things are issues.
Well, I don't know. I think it should be a fair, contested affair.
Affair.
I'm kidding.
That's a loaded word. All right. If nobody has a better one, then I guess we stick with issue. Again, like I said, as long as it's clearly a defined thing, I don't think it'll cause confusion. It's just kind of an odd use of the word issue, which seems to be something within these things, but not these things themselves.
Yeah, we did this. It's funny that you pinpointed that one issue. It was a little bit
That's
of
an issue within this meeting. That's right.
So other than, are there any other questions or comments on this section 2 with respect to when ORCP is and the Oregon Evidence Code apply to probate proceedings? So everybody's good with this language?
Yeah, I hate to be the one talking. There's one other in just capital G. Any other petition, motion, or show cause order? Would that be, again, a show cause, I hate to say proceeding, but it's what leads up to the order, right? Not the order itself.
You're muted, Matt.
That's funny. It's funny that I did that because I actually hit the button thinking I was already muted. So the problem there is that the way that we wrote, the reason that we wrote it that way is that typically in most counties, the way that the actual, and now I'm going to go ahead and use Jennifer's word, controversy comes up is that the show cause order, you get the show cause order ex parte. And that serves as the kind of initiating document which requires someone to show up in court at a hearing at which you may or may not, which the court may or may not order substantive relief. And so the order, typically there isn't an opportunity for counter pleading and things like that in response to a motion for a show cause order, because those usually are obtained ex parte.
Okay.
Hey, Matt Schrump, this is Rick. Hey, do you think that our statute regarding the prima facie nature of our DHS electronic records needs to be one of the statutes enumerated as an exception?
That's a good question. So Rick is asking about ORS 115.195, I believe it is. Let me just flip and double check that, which paragraph 2 has a specific standard allowing for admission of DHS records that meet the criteria set out there. So it probably would be worth including that somewhere just to note, because I think that would be an exception to what are otherwise the rules of evidence, because it provides for admission of evidence.
Matt, it's ORS 115.195.
Yeah.
Yeah, and it has exceptions for notwithstanding the rules of evidence. So that does need to be in there.
So I think adding that to that list in section 2, paragraph 1 would probably be a good idea.
This is Lorianne, and I think we did discuss this earlier this week, and we decided to leave this out. So just to kind of back up, and it's helpful to look at this in the broader picture of things. So as the default under Oregon law is that the rules of evidence and rules of civil procedure apply to all cases. And then what we're saying is in probate proceedings, there's an exception. They don't apply unless it's a contested proceeding. And then we list out the contested proceedings. So these are the proceedings to which specific ORCP applies and the entire Oregon Evidence Code. So the specific ORCP that apply to contested proceedings are listed out in subsection 2B of this draft. But when you go and you look at ORS 115.195, it's already saying, like in here, it already references, where is it?
It's in sub 2.
Yeah.
Notwithstanding.
Yeah, so it's already indicating that it's subject to, it's 4460, that's the evidence code, yes?
Yes.
Sorry, my brain is not. So it's already indicating that it's subject to the evidence code. And so if we want to say, it's already, so.
It's exempt, it's an exemption to the evidence code.
Right.
It's not saying that it applies, it's saying it's an exemption to the evidence code for this purpose.
Right. So the question is, do we want, if we go in and we say, so what you're, if I am understanding the suggestion correctly, you're wanting to add 115.195 to the list that's under subsection or paragraph B, is that right? The notwithstanding, blah, 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 the following are not contested issues in probate proceedings. Is that right?
I think that was where you would want it to go.
Well, that's not where I was suggesting to add it, but it may be that I was suggesting to add it in a wrong spot. I'm not sure where you're pointing to, though.
Okay.
I thought it
of
would go into the section 2, paragraph 1 in that list of statutes, but I might be wrong about that actually.
As a matter of statutory construction, I mean, that's a notwithstanding the OEC. I mean, that more specific statute, I mean, I don't think that you need to add that. I think there's no conflict between saying the rules of evidence apply in the following situations. And by the way, we also have this one very specific statute that says this comes in notwithstanding the OEC. I don't think there's a conflict there at all, but
The only problem with the statutory construction argument is that then the later made statute is the one that is considered to control. So this we're doing now later than the earlier one. And so then the question, it could create some issue at least. I mean, somebody may challenge it and say, no, now it's subject to it. And they just forgot to change that.
Could we have a signpost or some cross-reference to it in this statute just to make clear that we recognize that exists on its own?
Is there something?
Or would it work in section 2 and then in number 2C where it says the Oregon Evidence Code applies to a contested issue in the probate proceeding? Could you say something like except as otherwise provided by law or something like that?
That's problematic.
Yeah.
I think for the purposes of what we're trying to do here, that would create that opens up a whole host of potential issues.
Other ones, yeah.
Yeah, so the question is, going back to 115.195 sub 2, it has an exception to the Oregon Evidence Code from 460 to 510. Does that mean that it's subject to other parts of the Oregon Evidence Code and it's just that particular area that it's not subject to?
Yeah, it's for the purposes of being able to provide that documentation as proof of DHS's claim, and that it doesn't have to itself, it doesn't have to go through that part. I mean, if it was an entire proceeding that was being contested, then other parts of the evidence code would, arguably apply. Maybe it's, I think that personally, I think knowing the way that people like to pick apart statutes and say, but this one says this and this one says this, that it might be a good idea to put something in there that provides some clarity, at least with regard to 195.
Or would this be an area where just a good, robust, and clear comment in the report would indicate that the legislative intent is not to abrogate or to affect that other statute? I mean, if it's a question of statutory construction, we can affect that by salting the mind with a comment in the report that is not the intent. And what do you think, Lorianne?
Well, I still want to go back to make sure that we understand if we don't specifically call this out, what's going to happen to this statute?
Gretchen?
What effect this has on the statute? If you could give me just a second before I lose this train of thought. So where it is now, without it being specifically called out, is it's considered part of the contested proceeding. So because it's not specifically excluded from what is considered a contested proceeding, I believe, and correct me if I'm wrong here, Matt, that this would fall into the list of what we have said is a contested proceeding under subsection 4. So that means that it is subject to those specific ORs that we've called, or the ORCPs that we've called out, and the entire evidence code. But then this particular statute has an exception for a particular part of the evidence code. So it should not be affected adversely by what we're doing in this section 2. But if we go in and we specifically exclude it from being considered a contested issue in a probate proceeding, then it falls under the overarching exception that we're creating for all probate proceedings. So none of the ORCP or the Oregon Evidence Code would apply, which is not what how this is currently treated. Do I have that right? Somebody who knows more about how this statute is applied in practice might have a better handle on whether I've got the mechanics of this correct. But that's the way it's drafted right now.
This is Heather. I think that the 115-195 exception is not an exception to the entire evidence code. It's an exception to the hearsay rule.
Right.
Correct? That's all it is.
No, it's also an exception to the self-authentication. It's the idea that we don't have to have somebody there to testify about, yes, this is this, this is this. There's multiple exceptions for that.
So there's two. One is the hearsay exception. I'm looking right at the statute.
Mm-hmm.
And one is the self-authentication, right?
Correct.
Otherwise, the evidence code applies to it.
Correct.
So exempting this concept from the entire evidence code, I don't think that belongs where we're talking about. I mean, the exemption is specific. It's exempt from specific sections of the evidence code, not from the evidence code itself.
What about ORCPs? How do they apply to that proceeding?
You
Well,
mean what makes a claim?
That rule comes up in a summary determination proceeding. So
Okay.
I think part of my maybe confusion about whether or not this needs to be included is trying to grapple with the formation of this proposed language. So as I'm understanding it, Section 2, Paragraph 1 of the draft provides that the Oregon Rules of Civil Procedure and the Oregon Evidence Code do not apply,
Right.
except as in those listed statutes. And then Section 2, notwithstanding Section 1, ORCP 12 applies, all those other ORCPs apply to a contested issue, and the Oregon Evidence Code applies to a contested issue. And then Paragraph 4 describes what contested issues are, which includes a petition for summary determination. I believe, let me just follow that through. This is I know that you guys grappled with this, and I'm not sure that there would necessarily be a better way to do this, so I'm not criticizing you, but this is a complex statute of exceptions.
If you want that ORS 115 statute to stand on its own, would you put it under sub B as one of the proceedings that is not a contested issue?
May I, real quick? So Matt, this is other Matt.
Yeah.
Matt and I have actually tried cases against each other on this. And so let me sort of, from my perspective, here's how I think this works. If you have a disputed claim, it's going to get resolved in one of two arenas. There's either going to be a separate action that's required by the personal representative, in which case 115.195 isn't dealing with the new section that we're discussing here, that the section we're discussing here where we're carving out specific areas where the ORCP apply. That's a whole different case number, you know, filed in the civil department. And there, of course, the ORCP and the OEC apply by default. And what 115.195 does is it gives DHS a shortcut to get admissibility of their Medicaid file, or whatever or whatever their benefits file is.
So is that right, that proceeding in 150, that's a separate proceeding entirely? It's not just a motion filed in the probate?
Yeah, disputed claims go one of two ways. They either go through separate action,
yeah, right,
or they go through summary determination. And our separate sub-issue in our section that we've been working on specifically does not address summary determination.
Right. Does that solve the problem then?
I think it does.
By not mentioning it.
Yeah, because 115.195, you know, if Matt Schrumpf is going to go to a summary determination hearing, he gets to show up with we are in a very loosey-goosey sort of procedural system, and we know that. Summary determination has always been very loosey-goosey, and the judge sort of makes up the rules as they go. But the one thing that Matt knows is that he gets to show up with his file and it comes in. On the other hand, if he files a separate action that I'm defending, then he still gets to show up. But in neither event is that one of the separate issues or matters or controversies or whatever we're talking about that we're trying to carve out with this new statute.
All right. Are we satisfied with that?
Matt's explanation, I think, is all correct. Let me ask you a follow-up question now. So I had misread this. So paragraph 4B, actually paragraph 4BB is, as I read it, declares that a request for summary determination of claim is not a contested issue in a probate proceeding, which would mean then that none of the ORCPs or Oregon Evidence Code would apply. Is that correct?
I can tell you that we were explicitly trying to not call out the summary determination proceeding under Chapter 115 when we wrote this up.
Just to clarify, but that's different from a separate action under 1.5B, 1B. So it would be the summary determination that's filed in the same action, in the same probate proceeding under the same number, right?
Right. It's a petition filed in the probate, and the probate court sets a hearing in that probate docket for a hearing for summary determination. Yes, the separate action is a completely separate case number and follows the ordinary course of a civil action. But my clarification question is then that a summary determination within the probate proceeding, the rules of the ORCP and Oregon Evidence Code do not apply to that summary determination proceeding?
As it's drafted, I would say that yes.
Unless the court says otherwise.
I mean, the important thing here is that we're not changing the status quo. And so to the extent, Matt, that you're asking, well, wait a minute, what is the status quo? I will simply say, well, we're not changing it. My experience is that the rules in summary determination are whatever the judge says they are. There, 115 is not specific. It doesn't say anything about the rules. I mean, it doesn't say that you get to call witnesses
in a summary manner.
Yeah, what is a summary manner? Does that mean it's a summary judgment motion? Because I'll tell you that I've done these, and I have simply asserted that it's a summary, that it is like a summary judgment motion, that it's a paper trial on the merits, and I've had judges accept that. And I can also tell you that I've had full day hearings where I called witnesses and introduced exhibits, and that worked too. So I think it just depends.
So this goes back, I think, to an issue that Gretchen was raising a little bit ago, is if that's the case, if what you're saying, if I'm understanding you correctly, or the 115.195 sub 2, the default now would be that the evidence code and the ORCPs don't apply, right? Unless the court says otherwise?
Or unless it's filed in a separate proceeding.
Right. Is that the intention?
I'm sorry, was that directed at me?
Anybody that has an opinion.
I've never done one of these, so I don't have a sense.
My reason for asking is, and this is why I was saying it goes back to something Gretchen was bringing up, is because it does reference the a portion of the evidence code in there, the ORS 40.460 to 510. That indicates that the default is that the evidence code does apply. So why are we excluding that section if the default is that it does not apply? And we do need to resolve that ambiguity. I think it would be a good idea to resolve that ambiguity now while we're thinking about it, rather than having that litigated sometime in the future. But I don't know what the policy goal is of the group to be able to do that change.
I was just thinking about that exact issue, that if 115.195 right now says there's an exception to the evidence code, that implies that the evidence code otherwise applies. But if paragraph 4B says that summary determination is not a contested issue, and therefore under section 2 paragraph 1 the ORCP and Oregon Evidence Code do not apply, then we're creating surplusage that somebody's going to have to interpret. I'm not wanting to advocate for somebody to have full discovery rights against DHS for a summary determination claim, but I'll tell you that we get that sort of issue all the time. Of course, somebody wants to know and get from us the documentation for our claim. So, was the reason? So, Matt, you said you didn't want to change the status quo, and that the status quo is that summary determination is described as a summary in a summary manner. Do we think then that it is wrong or not desirable to have these ORCPs apply to the summary determination hearing?
Yeah, I think that, yeah. So the main use of summary determination is on small claims. So not yours, Matt. It's an opportunity for Capital One, which claims to be owed $800, to go ahead and get the decedent's liability on the credit card contract adjudicated efficiently without having to file a separate action. I think that it's real important, though, to point out that when we're looking at 115, 195, that it is more than a hearsay exception. It is more than a self-authentication exception. It is a substantive exception to the rule that a disallowed claim can't be allowed except upon competent evidence other than that of the claimant, which is a probate rule. And so I think that, because that's not the rule in an ordinary civil action. You can absolutely win a case based on the testimony of one person who's self-interested. So when we're looking at this statute, again, we were absolutely not trying to touch the summary determination process because, I called it loosey-goosey, but Brooks has much more cogently and persuasively said, look, we are in favor of preserving the discretion of judges to efficiently decide these controversies and craft a procedure that works and is sensible based on what's at issue and who's advocating for what positions. So the summary determination process, which some people complain about, is one that we don't have a problem with, but it's one that we didn't want to touch.
And Matt, let me interject again then. I think you're making some good distinctions, and maybe the reality is that if there's a personal representative that has disallowed DHS's claim and we have filed for summary determination, and under this new statute, the rules of evidence and ORCPs would not apply, so they would not be entitled to issue discovery in that summary determination hearing.
Unless
if they want that, then their option is to use their right to compel us to file a separate action. And then in that separate action, all of those ORCPs and evidence code would apply, and they get the benefit of that. And so it's a cost benefit to them. So like your example, the Chase credit card bill for $800, it's not going to be worth going through that. So the summary proceeding is the appropriate way to efficiently resolve that. But if you've got a claim like DHS's claim that are often for, tens or even hundreds of thousands of dollars, then if it's worth it to the personal representative to ensure that they have all of the discovery rights and procedures that they might want, then their remedy is to use the option to compel us to file a separate action.
Yeah, and Matt, I think that that's exactly right. I think that, in terms of, again, this policy of preserving judicial discretion to, craft a procedure to allow for what I'll call the proper summary determination of a given claim. Let's just sort of play this out the way you're talking about. The PR does not require you to file a separate action. You file for summary determination, and then the PR turns around and says, well, wait a minute, I want to seek some discovery on this. Then, and here I'm being absolutely practical. This is not in the statute. It's not in the ORCP. It's not in any UTCRs. I'm just being very practical. Is you've got to get some sort of conference with the judge to get the judge to make that ad hoc specific decision about what is the proper procedure to use in this, quote, summary proceeding to get this claim adjudicated in a way that's fair.
Okay, let me suggest something here, because I'd like to get beyond this section in chapter 11.
Yeah.
And this seems to be an issue between a very small set of lawyers who deal in these could we, and with the success we had with the subgroup between the last meeting and this, could we ask you guys to try and work this out outside of this meeting, and get through as much of the rest of 111 as we can, and come back to this at our next meeting after you've had some more time to do some thoughtful analysis?
Yeah, Lorianne, what do you think about that?
I think that's a good idea.
Okay.
And just to put this out there, my approach to fixing this would be to just strike out the notwithstanding 40.460 and 4510 and leave the rest of that sentence there. And I think that would resolve the issue. But I don't practice in this area. I don't know in practice how that would be implemented. So yeah, let's go ahead and do that. So would it be Matt then, and maybe Brooks?
Yeah.
So Matt Whitman, does Matt Trump want to be a part of this?
Yeah, you need one of us.
Oh, yeah.
Matt. Yeah.
Okay. Gretchen, do you want to be a part as well?
I'm okay if Matt's on it. And again, I'm looking at it from and I think this is something we always have to be thinking about, and it's not just this micro issue, is how what we're doing here affects another set of statutes. Because I could very easily see in that ad hoc meeting, Matt, that some attorney points out, look, it says notwithstanding. That means that the evidence code applies to summary determinations. So you have to allow me to have discovery. So we have to be aware of that. This is an example of that. We have to be aware of that in everything that we're doing.
And following up on Gretchen's point, that's what I have actually combed all of the probate statutes, and this was the only one that I found that was problematic.
Oh,
so
good.
with the reference to the evidence code or the ORCP. So
thank you.
Unless I missed something.
No, that's okay.
Totally
Thank you.
possible,
That's
but
great.
yeah, that is something. And we did discuss this earlier this week, but I think there might be some considerations that weren't voiced.
Yeah, we've had a good discussion of it today. I'm not sure, like I said, I don't want to spend the rest of the meeting trying to iron out this one little issue. So maybe you folks, informed by the conversation we've had here, see if you can work out. My guess is that once we hit on it, it's going to be, oh yeah, that's it. It's just hard to figure it out in real time with the rest of us here. And we've got a lot of other folks with other issues in the draft. Why don't we move on and let's do that.
So were there any,
that works.
Okay.
Were there any other comments on this section 2 on the application of ORCP and the Oregon Evidence Code to probate proceedings?
This is Judge Cobb, and I had emailed Matt and Brooks about my concern that, and I'm mostly doing this because I'd like there to be a comment that the references that the ORCP and the rules of evidence apply, especially under subsection 3 where it's identifying plaintiff and defendant, does not change the caption of the case. And that's been problematic. I think, Matt, you were saying that you've seen it as well, that attorneys change it from, the estate of John Smith to Mary Smith plaintiff, George Smith defendant, and it causes all kinds of problems and headaches as far as for the clerks administering this. And I understand that, if I had language to clarify it, I would have sent it to you, Matt, but I hope that somewhere in the comments that's not the confusion that attorneys read this and say, oh, we're going to change it to plaintiff and defendant. And Matt, I understand you sent me over, you suggested that I take this to the UTCR committee, and quite frankly, I'd rather walk over hot coals and bare feet before I go back there again.
Hey, I'm a former chair of that committee. It's a good committee.
I was on the accounting when accountings were submitted, and it drives one to drink, in my opinion.
So yeah, that's absolutely a problem. I think that it's a very practical problem. I'm not sure, generally speaking, forms of pleading aren't addressed at the statute level. They're addressed at the rule level. And if you don't want to do it, Judge, I will.
Oh, bless you.
And it's easy to do.
All right, so do we need to do anything more on that?
Okay. Why don't we move on to the separate document, and this is dealing with how to treat minors who are interested persons in estates. And I think it would be helpful if I just walk through what this does, and then we can have a discussion. So if you could make notes when you have comments about what things are doing or questions, and then we'll address those after I go through it all. Does that work for everyone? Anybody have objections to that? Okay. So section 4B is, what it says is subsection 2 says that if there is an incapacitated person, a financially incapable person, or a minor who is an interested person, that person needs to be represented by either a guardian ad litem, a special representative, a guardian or conservator, or if none of those have been appointed and the person is a minor, then the minor's custodial parent. Subsection 3 allows for the court to appoint a guardian ad litem or a special representative for an interested person. They can appoint both as long as the person's the same person. So you have one person serving as both a guardian ad litem and a special representative. Subsection 4, it has that if the guardian ad litem or special representative can represent multiple people. Sorry, there's a next friend reference in there that should be gone. As long as there's no conflict of interest between the interested person and the guardian ad litem or special representative. Section 4 has the guardian, there can't be a conflict of interest between the guardian and the people that they're representing, or between if they're representing multiple people, between those multiple people. And then it requires subsection C, or paragraph C in subsection 4 requires that the guardian ad litem or special representative has to notify the court if they become aware of a conflict of interest, and gives the court the authority to resolve conflict however they seem fit. And that the court has to provide their reasons for the appointment of the guardian ad litem or special representative. So that, for the most part, that is what was in the prior draft, except for the language about allowing the parent to represent the minor's interests if there hasn't already been a fiduciary appointed. Subsection 4C is the main new section in this.
Lorianne,
yes.
Sorry, just a question, and it may be simple, I just picked up on this. In 4A, it refers to the next friend using the definite article. I think that's the first time next friend has occurred in this.
That was a hanging reference from a prior draft, and as I was going through it, that should have been deleted.
Oh, that's the one you meant.
Ignore the next friend in that.
Yeah.
Section. Okay. Good. Okay. So section 4C has to do with, this is attempting to provide kind of a roadmap to an attorney to tell them what they need to do when there is a minor interested person. So first of all, if there's a minor interested person, the PR is required to make a reasonable search to determine the name and contact information for the minor's custodial parents, and to try to figure out whether a guardian or conservator has been appointed for the minor. Subsection 2 says that notice that is required to be delivered to a minor who is 14 or older, as well as the minor's custodial parents, and if there has been a court-appointed fiduciary, to that court-appointed fiduciary. One question I have in here that we can discuss later is whether we want that to be an and or an or. So it either, right now it reads as notice has to go to both the custodial parent and the fiduciary. And the question is whether we want it to go to the custodial parent or the fiduciary. Something we can discuss in a minute. And then if the PR is unable to locate a custodial parent, then the PR is required to ask the court to appoint a guardian ad litem if there's not already been a court-appointed fiduciary. Subsection 4 has a requirement, or it indicates that the parent, as long as there hasn't been a court-appointed fiduciary, that the default is the custodial parent can represent and bind the minor, which in my understanding is that that's kind of happening in practice right now, but that's not codified anywhere, actually providing the parent with that authority. So then the rest of subsection 4 has exceptions to that default. So I've left blank subsection or paragraph B right now, which is whether we need to kind of list out what the parent definitely is able to do. And then paragraph C has, what this is doing is, basically it requires, if the minor's interest in the estate exceeds the amount of money that can be just distributed to the parent on behalf of the minor, that the custodial parent's allowed to consent to like a statement in lieu of final account, but that consent doesn't become effective until the court actually approves the consent. I've struggled a little with how to phrase this, so that's something we definitely need to talk about. I think Judge Cobb might have some opinions on that. And then paragraph C, it is blank right now, but I'm not sure if you want to list out some things that the parent definitely cannot do. Subsection 5 says that the parent's authority to consent and bind the minor is suspended once a court-appointed fiduciary has been appointed for the minor. And then subsection 6 talks about conflicts of interest. And I think those are the main, I think it's going to take us a while to get through this section. So we can talk about the rest of this draft talks about notice, how to provide notice, who's entitled to notice. And then the one that's people might have, I think we need to talk about it's on page 4, ORS 112-272. This is talking about when when somebody triggers the interim. Oh my gosh, I can never say that interim. Thank you. That this is currently in 112-272. If a fiduciary triggers that, it's not held against the minor or the person represented by the fiduciary. And I threw in there for the parent, if the parent triggers it, but I think that's a policy call that the group needs to make. So let's go ahead and start working through section 4B to start. And a lot of this is directly taken from the prior version of this, from the draft. So basically the only thing in here that's really different from the prior draft has to do with what we're saying as far as that the parent can represent the kiddo. So does anybody have comments on section 4B?
Yeah, I do. This is John.
And
I see why you use interested person, but I'm concerned that this creates a really awkward situation. If you have a fully testate estate and you know in your bones that the will is valid because you wrote it and you helped it get executed, and you got to give notice to all of the heirs. The heirs are interested persons, and the heirs are often estranged. They're often strangers to the family. A lot of times it's really hard to even find them. But when you're filing that probate petition, you have no idea if an heir is a minor or under or over 14. You have no idea if the heir is financially incapable. You may not even know where they live. So you not know if there's a conservatorship or a guardianship imposed for them. You don't know any of those things. But this strikes me as imposing incredible burdens on the petitioner to do all of these things to get notice of the filing of a probate petition to an heir who is not a beneficiary of a testate estate. So I think it's kind of overdone. The other thing that bothers me is this conflict of interest language. We are all lawyers and we have legal rules and matters of legal conflicts of interest, but those don't apply to anybody other than lawyers. And this is kind of, and I think you have to keep that in mind. We don't know what a conflict of interest is. And to me, in the real world, there is probably always a potential conflict of interest. A potential conflict of interest just when two people disagree. So tying this to having to alert the court to a potential conflict of interest is, to me, kind of extreme, because you're always going to be alerting the court. And what are you going to do? You have to, you're always going to have potential conflicts. That's it for now.
Good. Let's talk about that notice question.
One question I have, John, is you mentioned that it puts the too much of the onus on the PR to figure out the information about the heirs of the decedent and if they're not beneficiaries under the will. And one of the things you said is that you don't know if they're minors, but in the petition you have to indicate what the age of any of the heirs who are minors. So I don't think that that is really, that this is changing that so much as far as figuring out if it's a minor.
But you always just say unknown. I mean, the heirs are usually insignificant. They get notice, even though they don't get anything under the will. They get notice because they have a legal right to bring a will contest. It seldom happens. It's extremely rare that happens because that somebody gets a notice, but it's a requirement. It's a constitutional requirement. But imposing all these added burdens on the PR, I think, is kind of extreme, and it's going to increase the expense of probates.
Well, that was my only comment. I just wanted to clarify that you're still required to indicate, even if you're saying, I mean, the practice might be to say unknown, but by statute, you are supposed to put the ages of any heirs who are minors. So I think it's a policy call about, you know, how much we're requiring the PR to do here. And so that's the discussion for the group.
Yeah, yeah, John's question is a good one for my purpose. Let's say not a minor, it's, a disabled person that maybe they're getting by with just a Social Security payee or something, and they don't have a formally appointed guardian or conservator. Must one be appointed in order for notice to them of the appointment of the personal representative be valid?
I think, why don't we back up just a moment to get back to, I think, the crux of John's objection to this language. It was focusing on whether we're saying the interested person. So is there a way that we can narrow that down so that maybe it's not necessarily at the outset of the probate, but something that happens after the petition's been filed and narrows the scope of who is required to fall under these new requirements?
Well, could you say that this section does not apply to notice under 113, whatever that statute is, unless the personal representative knows that the person is a minor or has a guardian, whatever?
Well, this isn't really regarding just notice. This is saying that a blanket, if there is somebody who's incapacitated or minor or whatever, that they have to be represented by one of these four things, four individuals.
Right.
So it's not quite that we can just accept a particular notice filing, I don't think.
This is Jennifer.
Lane, could I chime in again? What we've got right now is that you don't really do much of anything until some event arises where you need to get the consent of a minor or an incapacitated person, where there's something that you need to get to happen, and you need a signature, and you can't get it from that person. So you go get a guardian ad litem appointed.
Right.
And how we got here was we thought, let's just add a provision for a special representative instead of a guardian ad litem, because that's an easier thing to manage and to get somebody appointed for than to have a guardian ad litem appointed. It's a more cumbersome process. So now this has sort of evolved to some effort to make sure that every single minor or incapacitated person involved in a probate proceeding has adequate impartial representation. And that's kind of way beyond the original charge.
Well, this is Jennifer, and there are two parts to my response to you, John. I agree that we do not want to make it harder in the initial stages of the probate to give notice to heirs who are not devotees. And so maybe we can accept, those minor parts that come into play there. But as to the notice of people who are not financially capable, be they minor or incapacitated, them just simply receiving a mailed notice and having it have no meaning to them, there's not a meaningful participation in the process if they just receive notice and do nothing, receive notice of the final accounting that does all kinds of things to their rights and do nothing. And so, I'm uncomfortable with that person whose rights are being affected not having meaningful participation in the process.
Well, they're always free to come forward and get involved. And I think I agree. If someone's rights are being affected, they have a right to do that. But right now, I don't think it's broken. I think it's just fine the way it is. It's just that getting a guardian ad litem is a kind of a cumbersome thing. So add a special representative and make it simpler. But the whole probate system makes sense if you leave it to people to come forward and assert their rights. If you have to go make sure everybody is represented and knows what they're doing, and if anybody's rights are potentially affected, they get everything they need to know, blah, 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 then I think you've got the perfect becoming the enemy of the good.
Can I weigh in here for just a second? This is Jeff. I think the personal representative's duty is a fiduciary duty to all of the beneficiaries, isn't it? I mean, if they know of a minor or incapacitated person who's not going to get, adequate notice, that's what the judges, I think, are concerned about when you have minors and incapacitated persons without adequate representation.
But I think John's question was about the heirs who may not be beneficiaries.
Yeah.
That's a lot of work to go to.
Well, it's from the court's perspective, and I'm obviously one-sided here just because we're always looking for objectivity. We don't know whether an heir has some kind of claim against the estate for a will contest. And we wouldn't be in a position to know that, nor would an incapacitated person or a minor potentially.
Well, I want to understand better how this does apply to the sending out of the information to heirs, devotees, and interested persons. We know who that has to go to: beneficiaries under the will, to all heirs, and to anyone else that that falls under the definition of interested person. And I'm thinking of your typical not uncommon scenario, where you've got 20 heirs and maybe 3 beneficiaries of an estate. And the PR, your client gets you the names. Some of these are people that are barely known. But I mean, if any of those heirs are minors, before you can give effective notice, what has to happen? Does somebody have to be appointed as Because, you know, this may just be a garden variety heir, one of 3 little kids of a deceased sibling or something. Yeah, in order to give notice, does somebody have to be appointed as a guardian ad litem or a special representative for those heirs just to receive notice?
I don't think the judges always require that, but there are certain circumstances.
Under the statute, though, under this draft, would they?
Isn't that in 4C? And the first option would be to the minor's custodial parent.
So I think in practice now, the judges have allowed custodial parents to receive notice on behalf of like an heir who isn't necessarily interested. But there are circumstances when a custodial parent wouldn't be sufficient because maybe they are a beneficiary, you know, who would have sort of, I know John takes issue with hypothetical conflicts of interest, but if they're a beneficiary and they're receiving notice for a minor who might have a claim against the will that would affect that like device that beneficiary is receiving, the judge wouldn't say, great, just notify that parent. Does that make sense?
Jeff, I think you're right. It is the practice to simply notice the parent. I wouldn't say custodial parent. I would say a parent. And the courts just kind of say that's okay. The problem is there's no statutory authority for it.
Oh, I know.
So the reason we started down this path was to create that statutory authority to recognize the practice. And I don't disagree with John Dranius that we went down a longer path.
So can I give an example? I have this case right now. It's a very modest estate. There's a $400,000 small farm. The decedent left it in what looks to be a properly executed will to her longtime significant other, who they never married. That's the whole estate. This woman's family has been estranged from her for umpteen years. She has 2, the significant other, her boyfriend knows of 2 half siblings from her mother. Also knows that her parents divorced early. The father left. They never stayed in touch with him. He's been married again. He has other kids probably. They're all half siblings. And I've got to hire a genealogist now to find all of the heirs so I can give them notice that their half sister, who they've never met, is dead and left everything to her boyfriend, and do they want to come in and contest the will somehow? And now this would have me spend more money to inquire as to whether any of these people are minors or financially incapable, which I have absolutely no way of knowing without doing undue investigation. And if any of them are minors or financially incapable, I got to make sure they're represented somehow. That's kind of crazy. There won't be any money left over.
But John, this is Judge Cobb. In your search, this would, if you're financially incapable or incapacitated, that's a legal determination, right?
Yeah, it's a legal concept. Sure.
I think that, you know, your point, I mean, presently you have to go find the genealogists and all this other stuff to look for somebody. That's present law. This appears to be, as I read this, making a determination whether there's a guardian or conservator for any of these heirs. Because, you know, I could, as Lane's example, you know, I'm not doing really well, but I'm kind of getting by and my capacity is questionable, but nobody's got a guardian or conservator for me. And I don't think that it's up to the personal representative from this, as I read this, to make a determination that somebody's financially incapable or incapacitated. Now, with regard to the minors, you know, reasonable inquiry, I think, is the standard that we have in your scenario, and making a determination. And I guess, you know, I've seen petitions coming back to the court saying, you know, these are the circumstances, kind of like you've laid out. These are the people that we've found. Judge, what else do you want to have us to do? Is this enough? And the court goes, well, yes or no, or whatever they determine.
This is Jennifer, and I could see myself in this situation adding to my petition to open the probate something to the effect of the personal representative does not have knowledge that any of the above heirs are financially incapable or minors. Of course, we're disclosing the age anyway, and then that kind of gets around the issue that, you know, I haven't made a huge inquiry, but I don't have any knowledge. And then the other thing that I think is helpful is if in the bigger draft of the statute where we talk about who you have to give notice to, there is a new subsection that says that a person required to give notice doesn't have to do that for any person whose identity or location is unknown and unascertainable with reasonable diligence. So I don't, you know, maybe we add to that, you know, we don't have to do an air search or something, but I think there are ways around this concern, but I think it's good to think about.
Could you go to 113.145, which is the information to heirs and devotees and persons, and include in there that if known to the personal representative, and then incorporate what Jennifer was saying, you know, if you know that there's a conservator or a guardian. I don't think we say that explicitly in 113.145, and maybe that's where we do it, if known.
Yeah, that's right. There's no element of knowledge on the part of the PR. It's just an absolute fact about whether somebody is or is not financially incapable. And then you got to go make reasonable inquiry. You got to do some inquiry to verify those things. It's a lot of work for nothing.
Here's what I'd be satisfied with. I'd be satisfied with if you know that you have a minor beneficiary, that you can satisfy the notice requirement by providing notice to their custodial parent. And that if you have reason to believe that an heir or devotee is incapacitated, then you need to, you know, make a reasonable search for someone who has authority to act on their behalf. I think I came to the conclusion when we were working on this that I just want this to be notice. I mean, I like all of the other stuff, but I'm with Granius on the issue of how much work are we going to create.
Well, I think that, I think part of the reason, the complication with it just being notice is what is the legal effect of that notice then? You know, because it is, if you don't raise an objection and you've received notice, then you can't raise that objection anymore. Right. So where's the line? Where's the line? Or when more.
I think the custodial parent has an affirmative obligation to do something if they don't like it. That's part of parenting in our society. We're responsible for our children, but I know that not everybody has responsible parents. But I also know that there has to be a balance in the statute right. of how much work we go to.
Right. Yeah. And Heather, you just said custodial parent. I thought there was conversation earlier. Do we want custodial in there? Does it have to be the custodial parent?
After the small work groups, I think custodial parent is the right person, because you could have a non-custodial parent who's, for example, if it was dad's parent who died and giving notice to dad, who doesn't really have anything to do with the child or the care of the child, I don't think that's a very effective way to protect the child. So that, I mean, previously I
I
thought.
wasn't arguing. I'd heard both things here in the conversation, so I wanted to make sure that we were intentional about custodial.
So
Up and down the path, but I mean, we spent a lot of time on this, and it just got more and more complex.
So we actually, in the last big group meeting that we had, we spent a good portion of time talking about the parent and who was the parent as well. So I'm not sure if revisiting that is a good use of our time. But if folks feel strongly about that, maybe you could send an email to the whole group explaining your position on it.
No, I just heard both ways this morning, so I wanted to make sure we were talking about it.
Well, this is Jennifer again, and I agree. I don't want this to become any more complicated than it is, but I do want there to be effective notice throughout the proceeding, and so I think custodial parent solves that for a minor child. What if we do have somebody who's financially incapable? Let's say, you know, PR knows that one of the heirs who is not a devotee is in a care facility. Then what? Does the PR have a duty to get somebody appointed just so this person can receive information to heirs and devotees? I mean,
well, they have a fiduciary, this is Judge Cobb, they have a fiduciary duty. So if you know that they're in a nursing home and, you know, have no capacity whatsoever, how can you actually give them notice?
It's one thing to have a fiduciary duty to a person who's a actual beneficiary of the estate. I don't know, does the fiduciary duty concept extend to an heir who is not a devotee?
I would think not.
Doesn't it? I would think it has to, but doesn't it only arise if that breach of the fiduciary duty leads to some liability? So in the end, if John knows that these heirs are not entitled to anything and he's right on that, and they don't get noticed for some reason because they, you know, can't locate them or whatever, there's not going to be a damage in the end.
This is just, I think you're right, but then if you give notice to the lady in the nursing home who has no capacity whatsoever and she's entitled to, you know, something under the will, that's where I think the fiduciary responsibility comes in for the PR.
Well, you know, I don't think there is a duty to heirs who are not beneficiaries. The PR is appointed under the will. The PR is entitled to defend the will. The PR is entitled to assume that the will is valid. And if the will is valid, the heirs who are not beneficiaries under the will have no interest in the estate. So I don't think you have a duty to the heirs who are not beneficiaries under the will if it's a testate estate. If it's an intestate estate, different situation.
What if the person that is disinherited is a spouse and has a right to assert an elective share?
That is not the PR's problem. That is the spouse's problem, and the PR has no duty to that spouse because that spouse is not a beneficiary.
So the PR knows that the spouse is incapacitated in a nursing facility and has a right to assert an elective share, but lacks the competence to be able to assert that right.
Then you've got, if there's a conservatorship and the PR knows that, then you could notice the conservator and that's fine. But I don't know, when you have an actual beneficiary though, then the PR certainly has duties to the beneficiary. But we're kind of talking here about if there's nothing, if the PR is, you know, if the will says the beneficiary's going to get $100,000 and the PR is preparing to administer the estate to give the beneficiary $100,000, if that person's incapacitated or at questionable capacity or whatever, I mean, where's the breach of duty by not making sure that person's represented to make sure that there's a second person to count the $100 bills or something? I don't know.
Rick, I think that example of the spouse is can be easily addressed in the statute. I mean, for the most part, the PR is going to know if the spouse of the decedent is incapacitated.
Agreed.
So
You
if
think-
you have language that says, if the PR has reason to believe that the heir or devisee is financially incapable, not incapacitated, but financially incapable, the PR, you know, either may or shall give notice to any person holding, any fiduciary who acts on behalf of the financially incapable person. And that could be an agent under a power of attorney. It could be a court-appointed fiduciary. It could be a trustee.
Do we want to talk about, do we want to break out that initial notice, the information to heirs from the rest of this? Because that seems, once we have the estate, once the estate is open and our beneficiaries are identified, I think what we have in section 4B is perfectly workable. The difficulty, I think, is, from John's initial question, is that is a harder nut to crack for the purpose of that initial information that goes out. And so do we want to create a different rule for that initial information to heirs, devisees, and innocent persons? That is less burdensome, I guess, on the PR, less protective as well, but that's the policy choice, that we're not going to make the PR do an investigation of each heir to determine, you know, financial capability.
Well, and the other time it can come up is when you're trying to open a probate and you're not appointing the person with highest preference as PR. Say somebody's named in a will, or it's not the spouse or something, and then you've got to do notice.
This is Lorianne. What if we limited section 4? So it would be limiting basically subsection or section 4B and 4C to, instead of being interested persons, it would be the devisees if the will is testate, or the heirs if it's intestate.
Oh.
Would that resolve most of the concerns about this, other than the policy of putting this in there at all? But
yeah.
As far as limiting the scope, would that resolve some of the concerns?
Well, that helps me, but I think you still have this problem that even if you have an incapacitated beneficiary under the will, what I think keeps getting lost all the time in all these discussions that we have and all these efforts to try to make the system totally fair to everybody is that it takes time. And you need to get a probate started. And if you got somebody that is incapacitated and they're not, you know, why are they, you know, in the course of the proceeding, their interests need to be protected, no question about that. But you got to get the damn proceeding started. And if you have to get all of these hoops covered in order to give notice to somebody in order to file the initial petition, it just takes time and effort, and things go bad when these estates are not being administered. I think you ought to be able to just get the thing opened and then deal with all this stuff.
The only instance that happens in, though, is when you have a will that doesn't meet the formalities, or you have an intestate estate where somebody without highest priority has petitioned to be the PR. Otherwise, you can get it open without the notice, because the notice to heirs and devisees occurs after the appointment of the PR. So yes, you're supposed to do the notice to heirs and devisees within a pretty short time frame after appointment, but you can always tell the court, hey, we don't have it out because we have this problem. And sometimes that we have that. You have at least an address. You have to have the address to file your petition.
Yeah.
Well, and I don't know if this would work on giving notice where you don't want to have to appoint a fiduciary, is to identify the issue to the court and say, so-and-so is financially incapable, they're in a care facility, they have nothing, and person A is their power of attorney. Can I give that person the agent under power of attorney, can I give that person notice? And maybe the court could then say, sure, that's fine. And we don't have to, you know, reinvent the wheel.
I don't think you should have to ask the court for permission to do that.
Let me just try this, because what if we exempted the information to heirs, devotees, and interested persons from 4B, and then go to 113.145 and make a provision in there that if the PR knows that anybody entitled to receive notice under 113.145 has, a guardian, has a conservator, you know, any of these fiduciary status, that the notice has to be given to that person. It's based on the knowledge of the PR for at least the purpose of that of notice of the information heirs, devotees.
Yeah, that works.
And then once you've done that, for all the rest of the proceeding, 4B applies. But it seems like to make 4B applicable to what you have to do in information heirs and devotees, it really is going to be a burden to get an estate open, more probably than we're benefiting from. I'm not sure the work is necessarily worth the benefit for just that initial notice, unless the PR knows. And we can cover that in 113.145, and otherwise exempt that initial information heirs, devotees from 4B.
Yeah, that would be real helpful. I mean, it's, you know, once you get the process going, then you got time to deal with all this stuff and you got a budget to work with. So that makes more sense.
Okay, so let's assume that we change 4B to not apply to the initial notice to heirs and devotees under 113.145.
Right.
And we will then limit section 4B to devotees, or if it's intestate, heirs. Does anybody have an issue with how this is written in that case? So in that case, if you know that a devotee or heir, if it's intestate, is incapacitated, financially incapable, or a minor, or if the court determines otherwise, you know, on its own motion, that that person needs to be represented by either a guardian ad litem, special representative, a guardian or conservator, or if it's a minor and none of those have been appointed, the custodial parent.
Well, I'm not going to fall on my sword.
Then, oh, sorry.
Go ahead, Judge.
Judge Cobb, let's get you and then Rick.
Where does that come up then? I mean, at what point does the court know that 4B is kicked in? Because from what I understand, you're saying this is not going to be in the petition. It's not going to be in the initial petition. The estate's going to be open. And so how does this come before the court then?
Well, it will be in the petition if the PR knows when the petition is filed.
So there would have to be something, I mean, do we need to modify 114.035 to have a subsection in there that requires the PR to notify the court if they know or believe that a devotee or an heir, if it's intestate, is a minor? Well, they already are supposed to, but apparently unknown is commonly used. That they believe that somebody falls within this category of folks. Do we need to add something to 113.035 to specifically call that out in a petition? The concern is, think about this as a new attorney who has just graduated from law school, has not taken the bar because they don't have to, and they can't get a job, so they've hung up their own shingle, and they're reading through the probate statutes and to tell them what they are supposed to do in the petition.
God help us all.
Oh, you know, the statute is not intended to be a tutorial, and it's not supposed to be an owner's manual. It's a statute, so you can't do all of that. And trying to put practice tips in the statute, I think, is going too far. But the point's well taken. You know, it's nice to have the procedure laid out properly. You know, if you have, first of all, I think, in my mind, I think a minor and a financially incapable person should not be treated as the same thing. I think they're totally different statuses, and I think they ought to be addressed independently. But you get at the end, you know, when you get to the point of final distribution, if you got one of those beneficiaries, what are you going to do? You know,
Well,
if you know the beneficiary is laying in a care facility someplace and there's no conservator appointed, what are you going to do? Send her or him a check? You can't close the estate without getting this resolved somehow.
you're right. And that's why we have amended the section, what you have to put in a petition for distribution. It only addresses if there's a minor, but so this addresses an issue that Judge Cobb had brought up about the petition for final distribution often doesn't indicate to whom the payment's going to be sent on behalf of the minor. It only says that it's getting paid out to this minor. And so if you look at the very last section in this document, we have amended 116.083 sub 4E to require that a petition for a judgment authorizing distribution has to indicate to whom the distribution is made. So if you're really concerned about that, if the PR reasonably knows that one of the distributees is incapacitated and is financially incapable, that is, that maybe we should expand that to say if it includes a distribution to a person who is the PR reasonably knows is financially incapable or a minor, that they need to indicate to whom the payment's going to go.
Well, I think
I hate to put the PR in a position of having to basically assert that somebody is financially incapable. That could be a difficult thing to do.
Yeah.
If there's not been a determination, that's putting a hard thing on a PR.
So what if there has been a determination, but then you don't have to really indicate that because there's already a determination. But as far as the minor goes,
right? That's easy.
So this is Jennifer, and you could have a situation where the person's in a care facility and their affairs are being managed by a child who's using a durable power of attorney. And it would be logical that that person could receive the check and manage the funds for that person rather than having to appoint a conservator or something.
well, and if the person's operating under a power of attorney, if the check is made payable to their parent, then that person's able to deposit it and handle the funds that way.
So here's, I'd like to try and capture this before we get too far. I think what at least I'd like to do and see if this just works, that we exempt the initial information to heirs, devotees, interested persons from 4B. We go into 113.035 and where we say that we have to identify heirs and devotees, that we also identify this category of representatives if known to the PR, and then for the purpose of giving the information to heirs and devotees, we also have to give that if known, but only if known, and then otherwise 4B applies to every other proceeding in the estate.
Well, but what about if you have an invalid will that needs that special process, especially?
Oh, no, but that's not information to heirs, devotees, and interested persons. If you're filing a will under the harmless error or something like that, that's not information to heirs, devotees, and interested persons. That's a required notice when you file the will.
All right, and that's my concern, is getting the probate started when you have the will issue, or if you have a non-priority, non-preference PR.
What I'm saying is exempting notice to information to heirs and devotees. That comes after the PR has been appointed. That statute. So exempting that is not going to exempt these people from notice of a harmless error will or some other formal administration of probate. That all comes before the point in time at which you would give the information to heirs, devotees, and interested persons.
So Lane, my concern for simplicity at the beginning is really focused on ex parte.
Yeah, right.
If you've got a solemn form petition, then that's a different ball game.
I agree.
Yeah. And the harmless error statute will solemn proceedings. So
right
there, I think you got to be more careful.
But I'm just saying, if you exempt out information, errors, devisees, and interested persons under 113.145, that kicks in upon appointment of a PR. That's what the statute says. So by exempting 113.145 from the rules of 4B, you're not exempting the notice that would have to be given for a harmless error, will, or any other kind of formal administration, because that comes before appointment.
Yeah. Well, so how do you deal with the petition?
Well, I think that's what Lane had suggested, was going into 113.035 sub 5. I think it's sub 5. And you would, in addition to indicating the addresses for errors and devisees in there and the ages of any who are minors, you would indicate that the names and addresses of any fiduciaries for those people, if known to the person petitioning for probate. Judge Cobb, would that address your concern about the court being notified that this is an issue?
Well, I'm just wondering how the petition now if you want to see who gets notice, you look at the petition and say, these are all the people who get notice. You look at the proof of service or proof of notice and you say, oh, okay, all those people got notice. So if the petition is now exempted and then notice goes to different folks, do you to file something that says these are the minors and incapacitated people we found?
No, what I was suggesting is that we include in the petition known fiduciaries as well as heirs and devisees. And then we go to 145, and those are the same people who get notice.
So then 4B that we're looking at is still applicable with regard to minors in the petition, correct? You were taking out guardians and conservators.
Yeah.
Only.
I guess you could put minors into 035 and 145 as well, or these provisions in 035 and 145, and just kind of make those complete. But otherwise, yeah, I think you're probably right.
So if I'm understanding the petition, if you know there's a guardian and conservator in the petition, you list those folks.
Right.
You're also required to list the minors in the petition, right?
Right.
And then if you discover something subsequent with regard to incapacity or financial incapability, that's where the notice comes in, and those have to be identified. So it doesn't just look like you're adding people to the notice that I'm looking at, and it says John Smith, and I'm thinking, who in the cat hair is John Smith? Oh, well, he's the conservator.
Right. He should be in the petition as well as the information.
A follow-up to that point for later discovered, 113.145 paragraph 5 already has a provision for if you find an error that you could not previously locate, maybe that could be expanded to include if you subsequently determine that someone's a minor or incapacitated or financially incapable.
Yep.
And then there would be an additional filing, a notice at that point, the filing.
So that would be if you subsequently determine that one of the people that you listed in the petition is either a minor, because we previously used unknown, or that they are incapacitated or financially incapable, that you would then, under sub 5, 113.145, sub 5, that you would amend the filing to include their representatives, whoever it is that's representing them.
I think that makes sense.
Okay.
So does that need to be in the form of an amended petition, or could we make it some other easier way of notifying the court?
Oh, what does it say already?
Well, it says
Paragraph 5C says file in the estate proceeding proof of compliance. So you're just indicating the additional people that, if you found additional errors, you're just indicating those additional people that you've then provided notice to. Or if it was a minor or a incapacitated or financially incapable person, I think you just indicate that, you know, you identified that so-and-so was one of those conditions, and whatever relevant further info there was about who you served.
So it doesn't require an amended petition. It just supplements the information.
Right.
Yeah. Lorianne, oh, go ahead.
I was going to say, we've got about 14 minutes left, and we still haven't finished getting through this one section. So, so going down, so we've gotten through, I think, sub 2. We'll rework that so that it only applies to the errors if it's intestate, or the disease if it's testate, and that it doesn't necessarily apply to that initial notice. And then the rest of that section. So does anybody have an issue with, we already discussed this in prior meetings, about the court being able to appoint both a guardian ad litem and a special representative for a person if the same person is serving in both roles? Is there any objection to that? Hearing none.
I didn't follow.
So basically, it's allowing the court to appoint both a guardian ad litem and a special representative, if the court determines that that's necessary. But the person in those roles, it has to be the same person in both roles. And that was a policy decision that the group made a couple months ago.
Why would you do both? And what if they disagree? Or well, they got to be the same. Yeah. Why would you do both? I don't get that.
I think maybe
Heather
or Jennifer might be better suited to explain that.
We just had a conversation about, I know there's some questions about what authority a guardian ad litem has and doesn't have. So we were just belt and suspendering. That's what
It's permissive, so I don't think that's a problem. It's permissive.
Okay.
Require it.
So what about, Jennifer gave a good example a couple minutes ago about a person in a care home that's incapacitated whose interests are being adequately handled by their agent under a power of attorney. We don't have an agent under the power of attorney acting here to represent the person's interests.
Should we add that?
I would so.
John, could it be any fiduciary, or does it have to be an agent under a power of attorney?
You mean like the trustee? Yeah, I would think a trustee. Somebody's got fiduciary duties to the principal. A trustee would work. And if it turns into, a lot of this stuff is just, like if what you've got is a annual accounting, and you want to serve your annual account on people, giving that to an agent under a power of attorney or a trustee or something is probably plenty good. But if there are, if you're looking to modify the distribution scheme or something, you're trying to do something that's got more substance to it, and then you might look at that and say, well, you kind of need more horsepower here than the oldest daughter. You need somebody who knows what's going on and interprets all this stuff. And the court can step in at that point and say, I think you gotten to the point here where you need a special representative, and the agent isn't good enough anymore.
Well, and one other person who comes to mind is a special, the person who received a Social Security. I can't think of the name of them off the top of my head, but
Hey.
rep payee, because sometimes that's the only fiduciary that someone will have.
What if we change it? What if we say a fiduciary for something fiduciary, including an agent under a power of attorney, trustee, or rep payee? So it would be including, so it could be something more, but we don't have to necessarily go through and, you know, think about every potentiality out there.
Well, the problem is that the rep payee doesn't generally owe fiduciary duties to the principal, only with respect to the Social Security funds. Are you by implication expanding that person's obligations?
And I have the same concern about the trustee. The trustee owes fiduciary duties with respect to the trust, but
That's
not
true.
broadly.
Yeah,
That's true.
I think you're both right.
So should we limit it to an agent acting under a power of attorney?
How about an
That
agent?
one,
So then would the power of attorney have to specifically state some their broad powers then?
A fiduciary with authority. I wasn't looking for just the broad idea of a trustee or the broad idea of a special rep. I was looking for the idea of a fiduciary who has authority to act on behalf of the principal, and it could be a guardian of the estate in another state versus a conservator. It could be a guardian. It could be a conservator. It could be an agent under a power of attorney that specifically authorizes it. I was just looking for the idea of someone who not only had the fiduciary authority, but the fiduciary duty, those two things in one person.
yeah. I think you got it, Heather. You know, any fiduciary that has authority to act on behalf of the principal in this matter would be good enough for the statute.
So then
What are you telling Lori to do then?
do you need a specific reference in the power of attorney to do this particular thing? Because I think that's the catch-all for the power of attorney, is this type of thing.
Yeah, no, you wouldn't have a special provision in the power of attorney because nobody's ever written one that had that, because nobody ever knew we'd be writing this thing. So,
As long as you have the authority under your power of attorney to appear on behalf of the principal, like there's usually some kind of lawsuit related language. I think that's sufficient. I think a guardian of the estate or another fiduciary who has that authority to act on behalf of them. I mean, when we use the words guardian and conservator, we forget that those terms are not universally used in the U.S.
I think go back to Matt's point. If you state it differently, if you have the authority, you have it. If you don't, this statute shouldn't give it to you.
Well, nothing in this particular statute necessarily gives you that authority. It just says that somebody has to be representing the person's interests. So why don't I will take a shot at making those changes and we can recirculate that. We've got 7 minutes left.
Right.
So let's say.
I have a question.
Mm-hmm.
Lori, you'd mentioned the idea of changing 4B, I think it was, to say, or I don't know if it was 4B, to say something about that applies to heirs in an intestate estate and devisees in a testate estate. I'm not sure that meshes with Lane's example when you have a initial filing for proving a will that was not validly. And I wondered, does that distinction between heirs and devisees not just play out naturally on its own after the initial notice? If you have, isn't your notice obligations generally limited to whoever has an interest in that issue? So do you have to, if you have a testate estate and you've proven the will, is there an obligation after that point to provide notice to heirs on anything that you file?
I don't think so.
I think during the 4-month period before the 4-month period expires, if you're doing something, that you have a continued obligation to notice heirs and devisees, but I don't think that once you hit that 4 months, you do.
So I'm kind of wondering if that distinction will just play out naturally, and if we maybe don't have to write in a distinction, because there might be cases when you really should be doing that for heirs and devisees in the same probate, because it hasn't yet reached that point. Does that make sense?
Yeah. Yeah, so it's a good point. If you exempt out the initial information to heirs, devisees, and interested persons, you winnowed that down. And now we fall into the definition of interested person under 111.005, which interestingly, it says interested persons also includes fiduciaries representing interested persons. How about that?
And creditors. And creditors.
Oh, that's right. Sure, anyone. So, but I'm saying if we exempt out that initial information, heirs, devisees, and interested persons, I think you're right, Matt, that after that, interested person can sort of, it will be what it is under the circumstances.
So do you think we can leave that as interested persons? And
I do, as long as we exempt out that initial information, yeah.
Okay. Let's,
I don't think you can, I think you got to get rid of interested persons altogether. And it's either heirs or devisees, you know, beneficiaries, whatever you want to call them, but you can't, I don't want to have to make sure that a creditor is financially capable.
but let's say that you've got a family loan to the decedent by grandma, and grandma is incapacitated and she's a creditor of the estate. Are you saying that the PR wouldn't have a duty to make sure that notice of the estate is going to grandma's representative instead of to grandma?
Oh, if the PR has knowledge that there is a representative and grandma's incapacitated and she's got a representative, then you give notice to the representative. My objection is to the having to make an inquiry to determine whether or not grandma's gorked or not. And if it is and she doesn't have a representative, then you got to go get one appointed. It's not the, you know, that shouldn't be the people's burden.
All right. Well, here's what we're going to do. We've got our small group that's going to look at the issue that we looked at under, what was it, 115.135. Let's get that worked out.
195.
Let's create an exemption for the information, heirs, devisees, and interested persons. And then we'll make sure that those those include any known fiduciaries. And then I guess we'll just have to start here next time.
So, yeah, I think, sorry, this is Lorianne. I think it might be helpful if y'all could take a look at section 4C. So these are the new provisions providing a roadmap of what needs to happen when there's a minor involved. Try to skim over the interested person part of that, because we're going to deal with that next time. But as far as the structure of that and whether you think it works, and if you have concerns about that, if you could email those to Sandy before our next meeting, and that way I can have kind of some time to look into ways to draft around your concerns rather than trying to, I think that might help us be more efficient in the next meeting. If everybody's okay with that.
I agree, Lorianne. So for scheduling purposes, I think we're going to try, just keep moving this along. I'm going to try to schedule something in the first week or so of August. So that puts us in the, if that makes sense, I'll send out a scheduling link soon. For those of you, I know some people are out in the summer, but we'll do the best we can. For the small group, I have a list of who wanted to be involved. If you also want to be involved, let me know. I'm going to try to schedule that meeting for sometime next week.
All right. It's hard. We'll make it.
All right.
All right.
Thank you all for your persistence with the project. We're going to get it done. And eventually move on to e-wills. Talk to you all later.
Bye.
Bye.